Good morning, everyone. Thank you for joining us today for our latest edition of our PERAC education series. As you know, board members who are attending this live session will automatically receive 3 educational credits. We are recording this webinar so that we can save this fabulous presentation for posterity. Anyone who views the recording when we post it to our website can also earn 3 educational credits. You would just need to submit a training affidavit into Prosper. We have put the link to the presentation in the chat. I apologize for the mix-up with the link in the email. It was redirected to the wrong page, but the link is available here for you to download, and it is also available on our website. And with that, I will turn it over to John Parsons, our Executive Director. Thank you.
Thank you, Natasha. Good morning, everybody. Just a quick hello before the holiday weekend. I think it's fitting that we're doing veterans benefits today. We have over 230 attendees. I think this is symbolic of the importance that we place on getting our veterans benefits correct. It's just an area where nobody wants to make a mistake. We want to all assure that veterans are getting the benefits that they're due. I encourage you to pay particular attention to the military funding for veterans who are active. This is an area that can be a little tricky and requires coordination with municipalities. And this is the funding of their creditable service while they're away serving. So I know you all appreciate the significance of that. Just from a housekeeping standpoint, there are a handful of folks who haven't filed their SFI, Statement of Financial Interest, which is due on May 1st. So please, if you haven't done that, it's electronically stored. Just review your filing of last year and submit that. If you're having any technical difficulties, reach out to us and we'll make sure that part of it is corrected. The presentation today is by Patrick Charles, recently promoted Deputy General Counsel. Patrick's been doing veterans benefits from the first day that he arrived at PERAC, and I've yet to stump him with a question that he hasn't been able to answer on veterans. So I know many of you reach out to Patrick on veterans questions, and it's nice to have a reliable source there. So with 230 attendees, try to limit your questions. Patrick indicated either way, if you have a question that can't wait till the end, and raise your hand and feel free to ask. Otherwise, we'll be available for questions at the end as well. And with that, I will wish everyone a happy Memorial Day and turn it over to Patrick. Thank you.
Thank you, John. As John mentioned, I'll be covering veterans benefits today. We're going to cover a couple of areas, particularly what benefits veterans are eligible for, how they qualify as a veteran. That's probably one of the most important things we'll discuss, because as usual with Massachusetts, we don't make it easy. We always have to try to make everything difficult here. And so just qualifying as a veteran is a difficult process. And we've come up with our own definitions for some reason for veterans. So what we'll first start with is the qualification process. Who qualifies as a veteran? Go to the next slide, please. So on this slide, what we are talking about here is the wartime service and the Persian Gulf veteran. The reason that I've only started with this Persian Gulf veteran is because that is the most recent war that the statute, the definition of veteran, applies to. For some reason, we have not adjusted the statute in any way for the service in Iraq or Afghanistan, and all service since 1990 is considered wartime service because the Persian Gulf War is still going on. Now, Chapter 4, Section 7, Clause 43rd is the definition of veterans. The definition of veteran was put into statute many years ago, and it goes all the way back and lists wartime service back to the Spanish-American War, World War I, II, Korea, Vietnam, Panama. And those were relevant at one time very specifically because the statute used to require that to qualify for a veteran, you had to have a certain period of active duty time during wartime. Now that requirement has been lessened slightly in that now, in order to qualify for active duty service and be a veteran, you either have to have 90 days of service, one of which is wartime, or if you just simply have 180 days of active duty, you count as a veteran. Prior to, you had to have wartime service or you would not. So you could have served, and we've seen this many times, people in the 90s before some of the changes to the law, they were denied veteran status because they served from 1978 to 1980, and there was no period of wartime at that time. And so they never counted as a veteran, even though they may have served 2 or 3 years of active duty in the regular military, not in the reserves or the Guard. So you see here, we have the wartime service, and the Persian Gulf is still going on because Congress has never officially ended the Persian Gulf War. They were supposed, according to our statute, they had to pass a concurrent resolution, and they have never done that. So we consider it to be wartime service for the Persian Gulf, and that is how the Afghan and Iraq veterans are treated. 90 days, one of which is wartime. Unless you receive a service-connected disability, you get a Purple Heart, or you die in service, you will be counted as a veteran, even though you don't have the 90 days of service if one of those events occurs. And then as of 2004, any member that has 180 days, regardless of when it is served, if they have 180 days of active military service, it will count as being a veteran. Next slide, please. There are a couple of ways in which someone can be disqualified from being considered a veteran. The first is discharged on his own application because they are an enemy alien. This was put in during World War II. I have never seen this used, or have never seen this referenced in any document. I don't know if it's simply an outdated term nowadays, but I've never seen it, but it is in the statute. If you're guilty of willful desertion, I have never seen someone actually try to claim veteran status who had discharge papers in which they were guilty of desertion. If your service only consisted of Coast Guard auxiliary or temporary Coast Guard reserve service, you do not qualify as a veteran. And then if you have a dishonorable discharge, I have seen members submit DD-214s which show that they were dishonorably discharged. That precludes them from getting any veterans benefits through the retirement system, and it precludes them from being qualified as a veteran under Chapter 4, Section 7, Clause 43rd. Next slide. This is actually something that is a federal government law that I bring up because military service members have brought it to our attention a number of times, trying to claim that it provides them with benefits. Because the Veterans Healthcare and Benefits Improvement Act of 2016, it provided that a person in the National Guard who served for 20 years would be considered a veteran. The problem with this is this only qualifies them for veteran status for purposes of federal benefits. It does not apply to any veteran status for Massachusetts benefits or for Chapter 32 specific benefits. The statute requires a certain period of active duty. And so it is entirely possible that someone could be in the National Guard for 20 years and never have the required 90 days of active duty, one of which being wartime, or just straight 180 days of active duty. I have actually seen this in the past where I use this example in this presentation a number of times, but I had a member contact me and in fact brought this to our attention because they were in the National Guard in the Marine Corps Reserve Band for 21 years. That they were never activated for more than a period of 3 or 4 days at a time for purposes of individual performances. And so he couldn't get to the 90 days over 20 years. And he thought this would then qualify him to get the veteran status and also to be able to purchase his military time at a 5-to-1 ratio to get the maximum of 4 years. But I had to explain that that did not apply and this act does not change. Good story here is that he managed to ask to be activated and they activated him for 2 more performances and he managed to get to 91 days, I believe, in order to qualify as a veteran. Next slide, please. So creditable service for military leave. There are two types of creditable service that are eligible in Chapter 32. There's what I would call mandatory creditable service, which we're going to go over first. And then there is permissive military service purchases. The first three paragraphs of Chapter 32, Section 41H deal with mandatory military service. And the last paragraph, the fourth paragraph, deals with the permissive service purchase of up to the 4 years, which we'll cover in some detail later. The other two acts to take note of are Chapter 708 of the Acts of 1941. I put this in here because this is the historical act that established the right to military benefits, military creditable service. And this was obviously, as you can see, 1941. So that was right at the start of World War II. And you'll see that if you actually look at these statutes, some of them are outdated and some of the language is outdated because it refers to people and giving benefits to people who resigned their position prior to this law being in effect so that they could join the military for World War II. But it then established the whole process for 41H basically. And the other act is USERRA. It's the Uniformed Services Employment Reemployment Rights Act. This is a federal law that provides guarantees and benefits, many of which mirror what we have in Chapter 32, but there are some areas where the benefits guaranteed by USERRA actually exceed what is specifically stated in the statute in Chapter 32. In those cases, which I'll point out a couple of minor instances, USERRA will govern, and even though it is not in Chapter 32, benefits still has to apply. Next slide, please. So right here, we're just copying 41H, certain provisions in 41H. And if you look in the second line here, I just want to highlight the phrase leave of absence from a government unit. So this mandatory credible service is what we're dealing with when you have a member who is an employee of the town or the state, and they are called to active duty while they're currently employed, and they go on a leave of absence to serve in the military. When that happens, certain benefits kick in. Mostly, and most importantly, they get creditable service for any time they are on leave, but that creditable service doesn't kick in until they come back to service. So if you go to the next slide, you'll see highlighted in red the phrase reinstated or reemployed. This is important because if you go on active duty for 3 years and you get discharged from the military and you never come back to your employment, you do not get credit for that 3 years. Your creditable service is frozen on the day you leave, and you do not get anything extra unless the HART Act applies, which I will cover a little later. But generally speaking, if you leave and don't come back to work ever, then you do not get credible service. And in fact, you have to be reinstated or reemployed within 2 years of your discharge. And remember, USERRA is one of the programs that basically guarantees reinstatement rights. And this also allows for reinstatement to your governmental position here within the Commonwealth. The other thing is involuntary service is constantly referred to in this paragraph, that a person has to go on involuntary service. Anytime a person is activated, it is considered involuntary service. If you're activated, especially for the reserves or National Guard, we're going to consider it involuntary. The only time that you don't get credited as an involuntary is if the member resigns to join the military full time. Then time is not given. We have seen this in the past a few times where a member may be in the National Guard and then they get offered an active duty commission or something in the regular military, and they'll go into the Army and they'll now be a member of the regular Army for 10, 20 years, then do a full career. And that has happened a few times that I've seen. The other thing that I noted in the previous slide, USERRA, and this applies here as well in terms of, in order for you to get a creditable service under 401H, you have to be on active duty for purposes of service in a campaign. There are also under USERRA that you don't lose creditable service if you are on military training time, even though that time would not count as purchasable time and would not count as towards your veteran status. You would not lose creditable service for training time under USERRA. Next slide. So the first question is, how much service can be given under this 41H? And remember, this is the mandatory provision in which the service is given, it's not purchased. That service can be for 4 years unless the service is in excess of 4 years and it was involuntary service. And as I've said, if you're going to be activated by the military, it's going to be considered involuntary service. And you can receive up to 4 years, even if the member voluntarily agrees to the activation. Occasionally, you will see orders from the National Guard where the member consents to activation. And a lot of people have questioned whether that means that it's now a voluntary active duty. That does not matter for purposes of 41H. That is still considered involuntary. Now, if they go for more than 4 years, they might not be considered involuntary and given the credible service, but they may also still be able to buy time under 41H at some point. Next slide, please. Now, as John mentioned, the special fund for military service credit is a confusing area, but it is an essential area for the members' benefits, but also for the system to be properly funded for the service time that is being credited. So General Law, Chapter 32, Section 22.7 details what funds have to go into the military service fund, and also Section 22 will tell you when and how to calculate the benefit that should be paid in. Essentially, if a member goes on military leave, whatever they should have contributed had they continued in their position they held on the day they left, at the salary that they held at the day they left, should be put in, those contributions should be put into the system. They will be put in by the employer, and it will go into the Special Military Service Fund. And this is actually done on an annual basis. So anyone that was on leave during the previous year, their amount should be calculated. The system should be billed through the appropriation for the following year to cover that prior year's cost. Now, keep in mind that, as I said before, the person doesn't actually get military credit until the member returns to service. All of this money is kept in the Special Military Fund. It is not credited to the individual member's account, either during their military leave or when they return. It does not get credited into their account. Now, you see the second bullet point is 22.4b. This deals with when a member retires or dies prior to retirement with an eligible beneficiary under 12.2d. Then the amount in the Special Military Fund plus interest is added to the member's accumulated deductions and used to determine the amount of the annuity payable under Section 12. You go to the next slide, please. Funds on account for a member in the Special Military Fund do not always go to the member. If the member withdraws or dies prior to retirement with no member survivor allowance payable under 12.2d or payable under 12b, then the amount is used to reduce the amount of the appropriation of the governmental unit that paid to establish the military service fund. So if the member does not have any beneficiaries and is not entitled to a benefit, there's no benefit payable under 12 or 12b, then that money does not go into their annuity account. It just goes back to the system. Next slide, please. Now, this gets confusing because you could end up with a situation where a member leaves, doesn't get that money put into their account, and it reverts back to the system, but then they later rejoin or are reinstated to the system and they redeposit their accumulated deductions. So they leave service, they withdraw. Well, they don't get any of the military fund money. But then when they come back to another system and they purchase and do a buyback of all of their prior service, now the accumulated deductions must transfer into the pension fund with regular interest back into the military fund. So you could have a situation where you take away the money and then you have to get it back at some point if the person returns to active status in the system. Now, if a member transfers from one system to another, you transfer the funds from System 1 to System 2 only upon retirement or death with an eligible survivor benefit. So if a member has account in the Special Military Fund and they transfer tomorrow and they have 10 years of prior creditable service, then they have military fund time, you do not transfer all of the money in this military fund, at that point, you only transfer it if they retire or if there's a death with an eligible survivor benefit. So you'll actually be doing 2 transfers on account of this member's benefit. You'll transfer the amount in his accumulated deductions over to system 2, but you won't transfer any military fund time until the end. Next slide, please.
Patrick, I have 2 questions. Do you want to answer them now?
Sure.
Okay. So the first question, if the member does not come back, then why wouldn't we wait until the member comes back to bill the town city of the deductions the members would have had?
You can do that. The statute talks about it being done annually as part of the appropriation, and it's sort of unclear in the language to me whether it is referring to only people that should have been given the credit because they came back in the last year, or whether it applies to everyone that was gone for the year. So either way, we will not say anything if you do it either way, frankly. Some systems have a very hard time getting the funds, and it's just easier to do it on a rolling annual basis, saying you owe this, you owe this. And others, yet they have no problem with their town or their employing unit, and they can do it at the end. It's really I've seen it done both ways, and we don't question it either way.
Okay, and the next question is section 22.7. You stated the deductions should be based on the salary on the day they left. If this member is deployed for 2 years and would have received an increase, do we count that or simply use the day they left salary?
You would count it if there was, if they were part of the collective bargaining agreement and there was a raise, then you would adjust it going forward. I misspoke. I should have said that you started at that salary.
Thank you. That was it for now.
So the next few slides are going to deal with the purchase of military service time. This is a permissive service purchase and is not mandatory. And there are some criteria in 4.1H that are very important to keep in mind whenever someone wants to do a military service purchase. The first is the highlighted in red portion on the screen, that the member must be a member in service at the time that the purchase is done. No inactive member can do military service purchases. Now, that is not true for other service purchases that a member may have, like a redeposit of funds or something. Some of those allow for inactive members to do it, but in this case, you must be a member in service. And the fact that this also applies, this member in service, is also why in the event that a member dies, their spouse cannot do the purchase under section 12 of prior eligible time. This does not count as prior eligible time. Now, if you go down to the bottom of the screen, I did not highlight it in red, but about the 3rd line up, it says both former and present. And this is in regards to National Guard and active reserve personnel. I highlight this to you now because it's going to come up in a few slides about how National Guard members can get creditable service under this 4.1H purchase, even though the service that qualifies them for the purchase doesn't occur until they're already a member of the system. Now, traditionally, when you have a purchase of military service time, the easiest and most obvious way is member gets out of, let's say, high school at age 18, goes in the military till they're age 22. 22, they get out and they join the system. They have 4 years in the military, they can purchase it. And that's a basic, very simple, straightforward proposition. But you might have someone who was only in for 2 years, and then they joined the National Guard or the reserves, and they spent the next 15 years in, and all of that 15 years overlaps with their public employment. There will be a way for them to purchase that, and we'll discuss it in more detail in the coming slides. We can go to the next slide. I want to just talk about the 4 years. So as I said, it's a limit of 4 years total time. That's either active prior military service time, or if you're cobbling together some period of time at a 5-to-1 ratio for the Guard or reserves, the total purchase is up to 4 years. You pay 10% of the regular compensation when the member most recently established membership in the system. This is important because if the member didn't do the military service buyback in System A when they joined, but then in System B, they're given the opportunity, and they had transferred into System B, you still use System A's salary, But if they had withdrawn their funds from System A and gone to System B, you use System B's salaries. That's why it's the most recently established membership. Remembering you establish membership at the beginning, and if you transfer, your membership date does not change. The 5-to-1 ratio for National Guard and active reserves time must qualify as a veteran. I'm going to harp on this a couple of times. You can be in the Guard for many years, but you have to have activated military time of the sufficient amount, 90 days, one of which is wartime, or 180 total days of active duty non-training time. So active duty leave time cannot be counted towards your buyback. This is important when you have someone who has who qualifies as a veteran, and they want to do and they also are getting some leave time under the first 3 paragraphs because they were active duty while they were a member of the system. They were activated and went on military leave, and maybe they had 9 months 5 years ago that they were active. That 9 months needs to be subtracted from their total reserve time because they're already getting credit for it. So it has to be subtracted when you do the 5-to-1 ratio. Under the statute, and this is actually not in Chapter 32, so it's a good time to mention that. This is actually in Chapter 71 of the Acts of 1996, which allowed for this military buyback time. 180 days from notice to begin the purchase process. The 180 days appears nowhere in Chapter 32, which confuses a lot of people, and I get questions constantly about why are we putting this arbitrary number in when it's not in the statute. It's in the actual act that established the 4th paragraph of 41H, and so we have to implement it. And it says that you have to begin the process. Now, this can take many forms. Some boards will say that you have to start and actually start making payments within 180 days. Some boards simply say you need to fill out a form telling us that you're a veteran and that you're going to want to buy your time. And then they'll let you do it at any time up until retirement, essentially. And that's really a board policy decision. The other couple points on this slide: active duty for training, National Guards and reserves is excluded. That is time that does not qualify you as a veteran, and it can't be purchased as active duty service, even if it predates your military time. And when the Chapter 71 of 1996 was originally put in, it didn't even allow this process to begin until you had 10 years of service. Essentially, what that meant was the person could not purchase time right at the beginning of their career, and they couldn't use their military time to vest in the system. That was removed in 2002. The final point for this slide is, again, I'm harping on, you have to be a member in service. You cannot be an inactive member and do this purchase.
Patrick, I have several questions for
Okay.
this last slide. So the first question is, where is it written that a person first becomes a member of a retirement system, that they are given by the retirement system the right to purchase, according to PERAC form, notice of potential benefits pursuant to General Law, Chapter 32, Section 419H?
So the retirement board is supposed to give notice to the board, to the members, that they are eligible for this purchase, and that's under Chapter 71 of 96, and also the Act in 2002 reiterated that they are given notice. And we have always explained that the board should give notice of potential benefits to get the purchase. If a member is never given notice, then their 180 days can never begin, essentially. So it's in the interest of the system to do it, as well as the member being aware of their benefit options.
And then a follow-up question to that: where does it say that you have to start the purchase? I think you kind of answered it. Where does it say you have to start the purchase within 180 days of notice? The 180 days is only to be given the opportunity at some point to purchase the military time.
There are a number of Dalla and Crab cases that have said if you do not begin the purchase within 100 days, you are precluded from ever doing the purchase.
And must the 90 days or 180 days be continuous service, or can it be broken time?
It can be broken time. In fact, often what we see with some of the Guard members is that they'll be activated for a specific emergency situation, and it may be a 30-day activation, and then they'll go 3-4 years of Guard service without being activated, and then they'll be activated for another 3 months for another incident and then they'll be able to cobble together the amount. The only thing is that anytime that occurs, you must have the proper military documentation, and that is in the form of a DD 214 form, which we're going to go over at the end, how to read the DD 214s, but that is essential for active service. You must have a DD 214 that for each period of service that you are claiming, you have to have a separate DD 214. You can't just have one for your last deployment that then references that you have 2 years of active duty at some prior time. We need to see a DD 214 from every activation.
And is a reenlistment considered involuntary?
Reenlistment to the Guard or Reserves while a person is active on active duty, no, that is involuntary, yes. You can continue in service. We don't consider that to be involuntary. I mean, you're not volunteering to be active, you're volunteering to be still a member of the Guard or Reserve.
Okay, and then the final question I'll send to you for now. So say, for instance, the Boston Retirement Board never gave a veteran the right to purchase the time, and the member comes to Gloucester and wants to purchase the time. Who is liable for the 4 years?
Gloucester, it's where the service was purchased. The fact that the first board didn't give them the notice does not change liability or establish liability with that system.
Thank you. We have a few more questions, but I'll let you move on and then we'll break again for questions.
Okay. The next slide, please. So prior active duty and National Guard leave for active duty. So once a National Guardsman or a reservist, excuse me, once the National Guard or reservist is qualified as a veteran because they have the necessary active, they can do prior active duty of less than 4 years and purchase that. So they may, like, often we see people that were in the regular military for a year or two, then switched over to the reserves or transferred to the Guard. So they might come into your system with, say, 2 years of active duty in the Army, and they're still a member of the Guard. Well, when they start, they can do the purchase of that 2 years of active duty. And then as they accrue service in the Guard, using the 5-to-1 ratio, they may eventually get to where they have enough Guard service or reserve service that they could do the 5-to-1 ratio and get the further 2 years and end up with a total of 4. So it's possible that you will have members do 2 buybacks of military time. Some members will enter your system and not be eligible as a veteran yet because they've been in the Guard Reserves, but they've never done the active duty requirement, and they won't be activated until they serve, they've been a member of your system. Once they get the required activation time, then they can do the 5-to-1 ratio and purchase time as well. If you go to the next slide, we'll see that this is all because of 41H's requirement that it applies to the former and present members of the National Guard and Reserves. And it has been PERAC's long held position, and it has been upheld, that this means that if you accrue the time while you are concurrently a member of the system, you can actually purchase time that overlaps with your membership service. So the question often is, what about 41A? In no event shall he be credited with more than 1 year of credible service for all such membership service rendered during any one calendar year. This does not apply to purchases under 41H when it refers to the National Guard reserve time under the 5-to-1 ratio, because you're not actually purchasing the year of creditable service that you were working. You're purchasing a amount of credible service that essentially is invented by the statute. It is service outside of actual work service. And it's sort of like a free airtime type of situation where you're buying service that is created out of a combination of the statute and the calculation at the 5-to-1 ratio. So the 41A does not apply with National Guard reserve purchases when it's concurrent service. Next slide, please. So as I mentioned earlier in one of the slides, what salary do you use? You use 10% of the regular comp of the member when said member entered the retirement system. And if the member withdrew funds from one system and then seeks to buy vet time in a second system, you use the salary when they started in your system. But if there's a transfer you're going to use that first system's salary. So this could result in someone buying service many years later at a much lower salary than what you would possibly think, because all the salary data that you have from your system is much higher. But if they were a transfer, they will be able to use the original salary. Next, please. So when does the member have to pay? This is going to depend on the board, essentially. Boards can adopt a number of different policies and regulations on how to handle the purchase of this military time. They have to begin the process within 180 days of notice. That's to guarantee their right to the purchase and the benefit. But again, we're going to see that many systems do this differently. As I mentioned earlier, some systems just say, all right, fill out this form, and then when you're ready to pay, we'll tell you how much you owe, or we'll tell you now how much you owe, and when you're ready to pay, you pay it. Some systems say you need to give us a check for a lump sum amount within 180 days after giving your notice and being told you're eligible for benefits. It's up to the board. In answer to these questions, can the board allow someone to wait? Yes. Can they require a lump sum payment? Yes. They need to establish a policy that that's what they're going to do. They can't do it on a case-by-case basis, say, oh, you owe us a lump sum and you can do 5. You have to decide what you're going to do, whether you're going to let them wait, whether you're going to make them do it all at once. What you have to decide that and make it as a board policy. The best way to do that is obviously board regulation. You can allow a repayment plan. PERAC has always said repayment plan should be for up to 5 years, and only in extraordinary circumstances should they exceed that. Should the board adopt a regulation detailing its policy? That is one of the best ways to do it. There are a number of boards that have policies on how they treat their veterans buybacks. Now, the last one is a tricky one. Can the board adopt a regulation requiring interest if the member doesn't pay in a lump sum? The answer is no. However, I am sure that 1 or 2 of you on this webinar are in a system that somehow managed to get a reg approved that does allow the charging of interest. I don't know how it happened, but many years ago, some of these regs came in and they were approved either by PERA or even PERAC, perhaps, but that is just simply not allowed. So that part of your reg is not valid. Member cannot be charged interest. The statute does not detail any interest. It's simply 10% of the salary when you entered the system, most recently entered the system, and that's the only amount. There is no interest charging. Next slide, please. What if the member doesn't complete the buyback and transfer systems? This is one of those things that's not actually covered in the statute itself, at least not clearly. Though there is a CRAB case, it's actually a Superior Court case, Belmont versus Wellesley, PERAC, and CRAB, which details what happens when this occurs. And so you have a member who starts in System A, gets a bill for the buyback, starts a payment plan, whatever, and then they transfer to a second system in the middle of the payment plan. So what happens? How do they cover this? Well, according to this case, the money should be returned to the member, and then they have to start a new buyback in the second system. Now, for purposes of this, because they started it within the 180 days originally, they get the chance to do it in the second system, even though obviously they're well past their 180-day notice, but they started the buyback. You transfer the right to the buyback to the second system, but the money is supposed to be returned to the member, and then they start over in the second system. The question is, can System A transfer the money to System B rather than do a refund? Yes. The case basically says you have to return it to the member, but that seems to be an unnecessary step in many ways. And I know that many boards just do it as a transfer from one to the other. They just don't transfer liability or transfer creditable service. The second system takes the entire liability for the creditable service, and then the member completes a buyback for the amount at the second system. That seems to be one of the easier ways to do it, rather than giving it to the member, then having the member bring in the money, the check right to the next retirement board. Seems kind of an unnecessary step. Next, please.
I have some more questions. Are you ready for a few
Sure.
more? Okay. All right, so the first one, so just confirming, a member could have up to 8 years of military service for both the MLOA and buyback. For example, A member goes on MLOA for 4 years and is in the Guard for 20 years outside of the MLOA dates, therefore qualifying them for 4 years of buyback. The MLOA qualifies them as a veteran, and the buyback service is separate than from the MLOA.
That is correct.
Okay. The next question is a follow-up. It says, I thought you said that when a person first becomes a member, the member should be given the right to purchase the military time. If that is true and a board does not do that, then why does the liability fall to the subsequent boards?
Because the liability is going to go to the system that ends up allowing the purchase, and the second system is required to allow the purchase because the member can't be penalized for not being given the notice.
If the purchase of military time of 180 days is a state law, then how can a board adopt a regulation if there is a state law?
I'm not sure I understand the question. The board is adopting a regulation about how the purchase will be handled, when the payment has to be made. Nothing in the state, in the law in chapter 71 or in, I think it's chapter 468 of 2002 says that you have to complete the payment in 180 days. That's just, you have to begin the process. And so the board is free to adopt terms and conditions for the repayment. Particularly, the most obvious term and condition is repayment plans, the length of the plan, whether you have to do a lump sum or you can do a 1 year, 3, 5, whatever year repayment plan with equal monthly payments.
Should the salary used be 10% of the rate at which they were hired, or 10% of what the member actually earned during their first year? For example, if a member had a significant raise during their first year, is that raise taken into account?
The member, the salary is set at the date that the member is hired, and it can be 10% annualized. Also, if you do with the member, actually what the member received for the first year, if they're not doing the payment till after the first year, either one, I've seen it done either way, but it can be annualized because the person is eligible to make the purchase on basically day 2. So then you would have to annualize their pay.
Okay, so 2 more, but I think you just answered this last one, which was which salary to use. And the next one, the money that is returned to the member is without interest, correct?
Oh, if they transfer from system 1 to system 2, yes.
Okay, that covers it. Thank you. Am I on the right slide?
Yep.
Okay.
So the Military Pay Act, Chapter 137 of the Acts of 2003, this was done right at the height of Afghanistan and Iraq. And what these Military Pay Acts say is that the member is paid the difference between their salary and their military pay while they are on active duty. So you have a National Guardsman who gets called up to active duty. Let's just say that their military pay is $30,000 a year, but they would have made 60 had they continued working as a police officer. So the Military Pay Act says, well, they'll get their $30,000 from the military, but then we'll pay them the other $30,000 so that they're made whole and they're not losing any money by going on active duty. This money is considered regular compensation and contributions should be taken from that amount. What this does, essentially, it lowers the amount that the political subdivision must pay into the Special Military Fund for military service credit. So this member is going to get $30,000 paid by the city. So they're going to pay their regular 9 plus 2% on that. And then the other $30,000 that they're getting from the military, well, that should have had regular comp taken out of it as well and been put into the Special Military Fund. And so that money, then the employer will have to come up with that contribution as well. And that will then be added to the Special Military Fund. So essentially, the member gets made whole and the member is making their regular contribution on part of their salary, and then the employer has a lower amount that they're contributing to the Special Military Fund. So you'll actually have, in this situation, you'll have money going to the member's annuity account and then money also going into the Special Military Fund on behalf of the same member for the same period of time. Next slide, please. Now, there are local military pay acts. We've seen a couple of them. because some of them actually went so far as to just pay the entire amount. So that member would get 30,000 from the military and their full 60,000 from the employer. And so they're actually ahead by 30,000. And in that case, the whole 60,000 has deductions taken from it, and it goes, instead of to the military fund, it goes into the member's actual account. You need to make sure if there are any special acts in your member towns. I don't know that there are too many of these. Most of them had expiration dates, and I don't know if many of them have ever been extended. I know that the state one gets extended every so often, but the local ones, that's up to them essentially, and they'd have to get it passed through the legislature to extend it. The next one. So I told you earlier that the only way you get credible service under the first 3 paragraphs of 418 is if you're reemployed or reinstated to the system after your military leave. And there's this one caveat for the Heroes Earnings Assistance and Relief Tax Act, which are covered, the provisions of this are covered in 840 CMR 3.10. And they apply to the Heroes Act, the HART Act, I'm sorry, applies to members who are killed on active duty, or they are disabled while on active duty and unable to return to service. Why is this important? It'll be important for the benefit accruals under Section 12, and also, especially in the disabled situation, credible service towards ordinary disability. Next slide, please. So we have had to amend our regulations because of the IRS determinations about the HART Act and requirements by the IRS that the plan account for it. And so it's all accounted for in our regulations and not actually in the statute. And this is all covered by Memo 34 of 2013. But the next few slides, I'll go over what boards need to do, what benefits are guaranteed by the HART Act. So the next slide. Now, some of these apply to what boards should have done many years ago when we first implemented the HART Act, but it is still something that you need to be cognizant of because we still have people going on active duty. So the board needs to try to identify any members who died while on active military leave or that were disabled on military leave and unable to return to work. Got to contact the member if possible, beneficiary to determine what, if any, additional benefits are available. Next couple of slides, we'll go over what those benefits may be. Next slide. Under 12.2D, a benefit amount may need to be recalculated, or a member may be eligible for an increased benefit or to have their credible service increased for purposes of calculating a 12.2D benefit because they will be getting credit for time even though that they were on leave, even though they didn't return to work, especially if they were obviously under 12.2D if they were killed in the line of duty. The only thing, beneficiary cannot utilize makeup payments to purchase any other 401h time that may be available. Oftentimes a member who passes away, their spouse can, if they had money to redeposit for a prior service buyback or money that they had withdrawn, they can do that deposit. The spouse can do it. That doesn't apply for military service. So you can't purchase. If the member never bought 4 years of military time, they can't purchase it. They'll still get credit for the time that they were on leave, but they can't get credit for any prior military service time that they neglected to purchase prior to their active duty. Next slide, please. What happens for a disabled member under the HART Act? If a member was denied credible service or failed to be reinstated, then they may now be eligible for benefits because of the changes. My guess is most systems have already addressed this, and they're no longer denying members creditable service based on the fact they don't return since the HART Act was implemented so many years ago, but just important to keep it in mind in case you do find one that became disabled, make sure that they get whatever benefits they are entitled to. And if you had a member who withdrew their account because they didn't qualify for any sort of benefit, they didn't have the necessary creditable service, they didn't qualify for ordinary or superannuation, then they should be allowed to redeposit the funds. And then any funds that were transferred from the Special Military Reserve Fund should be redeposited back into the member's account, and then the benefit can be calculated. Next slide, please. Okay, this is a an act of 2018, chapter 218 of 2018. And this provides a new creditable service purchase for a group of people who I put in this presentation, even though they are not going to qualify as veterans, but they are often considered and treated, or if they consider themselves as veterans, and you'll get questions at the board about certain buybacks. This buyback only applies to two categories of people. If you go to the next slide, it's the United States Public Health Service Commission Corps, the National Oceanic and Atmospheric Administration Commission Officers Corps. I guess these organizations are run on military lines, but they are not actual branch of the military. I got this information right from the website of these two organizations in order to do this. As far as I know, this is only applied to a few members. I know the state board has had this apply. I don't know if any local boards have ever seen this. If they have, I'd love to hear about that, but it's not something that is common. These are very small organizations, but they are allowed to purchase 4 years, similar language to the veterans. They can purchase up to 4 years. They pay the salary that 10% of the salary at the time that they started. Oh no, actually they pay the amount they would have paid had they been contributing. I'm sorry, they don't have the 10% language, but it's the first year of membership. So it's similar language. There's a little bit of an interesting thing in the language of the statute. It actually refers to people who has retired or will retire after 11/1/75. This language is very weird to put into an actual Chapter 32 provision, especially one going back that long. And so my guess is it must be that someone prior to 1975 wanted something to do with this time. I don't really know. I've never heard of who it was, but it's just a little odd note about the statute. Next slide, please. So Chapter 218 and whether or not these members qualify as veterans. They were not added to the definition of veteran in Chapter 4. So they do not qualify under veterans, and they cannot purchase any time under 401H. They're not eligible for any sort of active duty leave time or anything like that. They're also not eligible for the increased 50% ordinary disability benefit that is available to veterans. They're not eligible for the $15 per year when they retire for super or for disability, or if they are end up being in the state police, they're not eligible for the $15. So they do not qualify as veterans under our statute. Next slide, please. So I mentioned they're not eligible for ordinary disability. What is ordinary disability and why is it different for veterans? So veterans have a 50% provision. If they have 10 years of creditable service, they get a 50% disability pension, which can obviously can be significantly higher than what another person with only 10 years of creditable service would get as an ordinary. The one thing here that's highlighted is, can you use veterans buyback time to purchase to reach the 10 years? Yes. And that is the change because of the acts in 2002, which allowed for the purchase of service prior to vesting. Before 2002, you had to have 10 years of service before you could even do a buyback of prior military time. This does allow you to get to the 10 years. And also you will get to the 10 years possibly if the HART Act applies and you're disabled and have that credit, but you just have to get to 10 years and then you get a 50% disability pension. Keep in mind, because the person is getting the 50% disability as a veteran under ordinary, they don't qualify for the $15 a year provision that was referenced for supers and for accidentals. Next slide. So here's the $15 that I was talking about. You get the $15 up to $300. I know that there is legislation every year to either up to 15 because it hasn't been updated since I think the 60s. They've added some new people to get it with disabilities getting it and so forth, but they have not changed the $300 a year. And Group 3 veterans are that's state police. They get it actually under Section 26, not under Section 7 or Section 5, I mean, sorry. So the next slide. veterans benefit of up to 300 is added to the retirement allowance after the 80% limit is calculated. So we don't care about the 80% limit when it comes to the $300. It just gets added at the end. That would be, and that is because if you didn't, then technically the member wouldn't be getting the entire $300 allowance. So it can exceed the 80% when the veterans benefit is added. Now, if you want, do we have any questions right now? Because I'm going to start going into how to look at these military service documents. So if we want to have any questions beforehand, I can do that.
Okay, yes, we have 3 questions at the moment. If on a payment plan, can they get credits for the amount they have paid for to date?
They don't get credit until they complete the payment necessarily. This is one of these areas that is a little tricky because there are some cases out there that have said that you have to do the entire purchase, but we have always interpreted it that you can do a partial purchase. So if you only want to buy 2 years, but you had 4 years of military time, you can do just a 2-year purchase. So you need to decide what you're going to purchase, essentially.
Can you explain how the Brave Act benefits are implemented for shift workers? Is it full payment from military and municipality for the first 42 24-hour shifts while on active duty?
So this is referencing the Military Pay Act. I'm not sure of the answer to this question. I had never considered if it was treated differently for, my understanding has always been that it was based on whatever the salary the member would have received for their regularly scheduled position. So if they're a 37.5-hour position, they'd get that. If they're a 40-hour, or I guess there are public safety that are over 40-hour as their regular, so it would count towards the whole thing. But I can't guarantee that that's the correct answer. I've never had that question before. I'd have to research it.
And final question for now. Active member goes to military training, injured at training, and will be out of work for some time. Military is paying his full salary. Does the municipality pay into the special military fund for this time? And does the member get regular service time while he is out injured?
Yes, that's actually not covered by Chapter 32. It's actually covered by USERRA. It's a federal benefit that it guarantees them that they don't lose benefits in terms of their pension system. So they would get creditable service.
Okay, thank you. So that's
Okay.
it.
So we're going to go over some of these forms. And one of the things that you have to understand about the military, it's like every other bureaucracy, their forms are either outdated or they make a change and it looks nothing like it from 1 year to the next. And so you could have 2 members that present you with DD 214s and they don't look anything alike, depending on when they served. So these are just a couple of examples that I found. Frankly, a lot of these are chosen because they were the most legible copies that we had of DD 214s, because you'd be amazed how people treat their forms before they bring them to the retirement board and they get all crumbled up and they're just impossible to read. And so it's very difficult for us to find some really clear examples of what we're trying to do. So this first one, I kind of spoiled it by labeling it not a veteran training. So you kind of get a highlight as to what the deal is here. But if you look at the very top of the screen, under box, right next to where the name is blacked out, you'll see Army, ARNGUS. So they're in the Army National Guard. So right there, that means that you need to take a good look at whatever form you're being presented, because National Guard has different requirements for active duty than if it simply said Army at the top. Because if it says Army at the top, they're in the regular Army, then any service that they do is considered active duty service. Doesn't matter when it was, for how long, nothing. It's just active duty. Doesn't matter if the whole thing is active duty training. They have like 6 months worth of training time. That counts for the Army, but for the National Guard, you have to look at the period of service, but also what type of service it is. So if you look at section 12, box 12, I should say, on the big box that starts with record of service, this shows that the member entered the service on January 7th, 2014, and was in, under box B, until May 10th of 2014 for a total of 4 months and 4 days. So this is more than 90 days. So that's the first thing you look at. So they have more than 90 days and it's 2014. It's technically wartime service. But you still have to determine whether this was active duty or whether this was active duty training. And so at the very bottom of the page, you go down to box 23, type of separation. This is going to tell you that he was released from active duty training. Therefore, this 4 months and 4 days does not count towards ever qualifying the member for veteran status. It may count towards their 5-to-1 ratio if they ever get the active duty time, but it does not qualify them as a veteran. And I'll just point out, because if this was a slightly different form, you would still have to check box 24, which says character of service. And you need to see the word honorable there or under honorable conditions. But this person does not qualify as a veteran based on this form alone because they do not have active duty non-training time as a member of the National Guard. You go to the second slide, the next slide, second form. This is one of the only examples that I could find of someone who got discharged for disability. So it's a fairly old form, but the form is similar today. And what you need to see on this form is that at the top, it says Army. So this person enlisted in the Army, but they clearly were injured during basic training, or they discovered a disability, a medical condition that disqualified them from service while in training. And so if you look at box, hard to see it, but it's a little bit down and it's in parentheses right in the middle of the screen. It says physical disability. And right above that says that they were discharged. So what this generally means is that it was determined that they had some sort of medical condition that was not discovered until partway through training. Oftentimes I have heard of this being something like asthma or some sort of atrial fibrillation or something where the heart is not picked up on your just basic physical, but it is picked up once they start the very intense training. So this person does not qualify for anything because they don't have 90 days. There's no disability, service-connected disability here. It's a pre-existing condition. They weren't discharged because of injuries sustained while on duty. So I actually could not find an example of someone who suffered the injury within less than 90 days. I just couldn't find anyone that's ever applied or submitted a form to us. Some of the boards may have seen it, but we just didn't see that form. So I'll go to the next one. And this is actually the easiest example and the easiest thing that any board can look at and find and figure out. Because you're going to always start at the top of the screen next to the name and figure out where they served. Air Force, REGAF. They're in the regular Air Force. You don't have to worry about the reserves. You don't have to worry about the National Guard. You just have to worry about, do they have the service time necessary to qualify as a veteran, meaning 90 days, one of which is wartime, or 180 days. So you go to box 12 right off the bat, and you look at the period entered service, period separated from service, net active service this period. 4 years, 0 months, 0 days. What's the maximum that you can buy? 4 years. This person is straightforward, simple, 4 years. Anything that starts net active service that starts with more than 4 years, it's easy, it's just 4 years, but you don't really have to do too much thinking about it. The only thing that you really have to do is go down to the bottom of the thing and look at the boxes 23, 24, they're on the same line. You'll see the person was released from active duty, character of their service, honorable. As long as you see that honorable, you see that they were in the regular military, not the reserves or National Guard, and they have 4 years, they're eligible to purchase 4 years of time. This is going to predate their creditable service, their membership service. So you can go to, and I just want to point out under box 14, right under the record of service, you'll see that there's a ton of time listed here where he was in basic military training. He was an aerospace medical service apprentice, second phase of apprenticeship. He was on the health response team. He went through an Air Force training course. Now, we've talked about that military time as training doesn't count, but that only applies to the National Guard and Reserves. I've had people ask me about, well, he has 4 years of active duty, but he spent 9 months in various trainings. If they're in the regular military, non-reserve, non-National Guard, we don't care what military training they had. That all counts towards their 4-year active time. So go to the next one. And this is just an example of the old DD-214 form. And the biggest difference that I have to always draw people's attention to here is character of service. It's now at the top of the page or near the top of the page instead of all the way down at the bottom. And that's just to point that out because you will see these older ones from the Vietnam era that look different and you'll have trouble finding some of the information because it's just a little bit changed up and they don't do, you know, the box that has the statement of the current service is much smaller. There's not as much detailed information about prior service and prior activations. So this person was in the Army. They had 1 year, 2 months, and 28 days, and they were discharged under honorable conditions. So they qualify for as a veteran, and they have the 1 year, 2 months, and 2 months and 28 days. The question that I often get asked is, you know, a lot of times boards send in these forms and ask us to certify how much the person can purchase. And I always put under the letter the years, months, and days. And they ask, well, credible service is only done in whole months. So why are you telling me that they have 14 days or 21 days? And the answer is because you can keep that time aside and add it to some other credible service that they may be able to purchase from another buyback provision. Maybe they have 14 more days from a previous purchase or from some other credible service, and then that will get them another full month of service. That way they can get the full credit. So that's why we include the days. If you want to go to the next one, we're going to start talking about some National Guard issues, which the National Guard is more difficult. Anytime you deal with the National Guard and Reserves, just the forms are different to get their total service. With a regular military personnel, they'll get a discharge, a DD-214 at the end of their enlistment period. So if they're enlisted for 6 years, at the end of that 6 years, they're going to get something that shows that they were in for 6 years. But with the National Guard, they don't get a DD-214 if they are discharged from just the Guard and not from an active duty posting. So what you'll see is a form like this, which is an NGB Form 22. And this will show that the member was at the very top. It'll say they're in the Army, and then it'll say National Guard of Massachusetts. It could be the Air National Guard. It could be a number of things. And you'll see that they were in, if you go right to the very middle, length of this service, 6 years. Okay, so they have 6 years of service in the National Guard, in the Army National Guard. But what this form doesn't tell you is whether or not they've ever been activated or whether they qualify for veteran status, because you need the DD-214 to go along with this document. This just tells us that they were in for 6 years. And so if they have activation time, they may be eligible to purchase a little over a year's worth of service when they do a 5-to-1 ratio. But with just this form, this person is not a veteran under our statute. If you want to go to the next form, this is another National Guard form that is used to show total time for purposes of the 5-to-1. I'll reiterate. This form alone will not make them a veteran. They need to show us a DD-214 showing activation. But once they've passed that threshold and it's been determined that they are a veteran and are eligible to do the 5-to-1 ratio, this form you can use to document the 5-to-1 ratio. If you look down at the bottom of the screen, you're going to go, you'll see the very bottom, it talks about 5/20/1987 to 5/19/1988. And it'll go up each year. So you can calculate the total number of years that they were in based on these enlistment dates. It's annoying to have to do it that way because it's not obvious, because sometimes what you'll see, and I've seen this many times, you'll all of a sudden jump from 1997 to 2004 because for some reason they were out of the service for 6 or 8 years or 4 years, whatever, they didn't re-enlist, and then they come back to the reserves or guard. So you have to do it line by line to make sure that you're accounting for each year and not including years that they were actually not enlisted. So if you want to go to the next slide, we're wrapping up here. This is the calculation for the 5-to-1 ratio. I think it's pretty self-explanatory, and I hope it is, because I don't actually know how to do the math. The next slide after that is veterans legislation for this current session. So there are a couple of bills that are filed this year to actually change some of the provisions that we've just talked about. Senator Bielis and Rep. Paracella have both filed the same bill, an act relative to veterans buyback. And this removes the 180-day requirement and allows the member to purchase within 1 year of vesting in the system. So it would allow the person to do the buyback immediately upon entry into service, but they could also have up to the end of their, essentially their 11th credited year to do the purchase. And it would also give a one-time opportunity for anyone that was previously denied the buyback to do the buyback within 1 year of whenever the legislation is passed. So this has been filed by PERAC in the past, and it has gone through the Public Service Committee, but has never been passed by the both chambers. And so this session, 2 legislators have actually filed it for us at our request. And so we'll see how those move. The other, next slide, please. The other recent interesting thing is there have actually been 2 cases recently that came down from DALA that we're going to be watching pretty closely, because they've sort of turned some of this presentation on its head with the conclusion that the DALA magistrate reached. Both of these cases involved whether or not the 180-day period had been, whether the member was excluded from buying back time because they missed their 180-day window. And in both cases, the magistrate actually found in favor of the member because of the way that the act in 2002 was written. I believe it was 2002, where they changed the 180 days, where they took out the 10 years that you couldn't do it until you invested. They changed some of the language there, and it has always been interpreted that that means that the 180 days is still in effect, and now it's no longer tied to vesting. But the magistrate says, no, in these cases, he's saying the 180 days doesn't even begin until the person is vested. So they can do the purchase in the first 10 years, but until they actually vest, they don't have to be given notice, and their 180-day period doesn't start. So I think it's Neil Gauk versus State Board. That is on appeal to CRAB. So we will be watching that to see how CRAB rules on that matter, because this is completely different than I could probably pull up in 5 minutes of research, 12 to 24 cases where the 180 days has been very strictly interpreted. So if we go to the next slide, we'll wrap up with, there's a few things that you should remember. Veterans is defined by mass law, not federal law. This is very confusing. A person can be regarded as a veteran by the federal government. They can be receiving veterans benefits, but they may not qualify under Chapter 4, Section 7, Clause 43rd. They just don't qualify under our mass law because we've created our own definition of what a veteran is for purposes of benefits. The other thing, always make sure that the member was either discharged honorably, it says honorable discharge, or it says under honorable conditions. If it does not say that, then that DD 214 and that service time is not usable. Wartime service is no longer necessary if they have at least 180 days of service. This is really sort of starting to fade out of relevance in terms of the fact that the Persian Gulf War has been going on since 1990. But what you will see, and systems for years have seen, is these members that have service time in the late 70s and mid 80s where there was no conflict listed, and they may not have qualified traditionally under the old definition. With this 180 days, those people will qualify for service as long as they have the 180 days, because they have that requirement now rather than having wartime service. Also, you must have a DD 214 for the member for any service that they want to purchase. If the member had 3 years of active duty and on the bottom of the page of the box 12, it says that they had 3 years of prior active federal service, they need to have a separate DD 214 in order to qualify for anything for that other 3 years, or for, in this case, what would amount to 1 more year of purchasable time. They have to have it for each. You have to have a separate DD 214. You have to see that they were discharged under honorable conditions or honorably under each one. With the NGB 22 forms, you need to have those along with the DD 214s if they're guard service to calculate. There are some other forms for reservists. That there's a 256 form that can be used for reservists, but again, that will only show their total reserve time. They may have discharge documents that say that they were discharged honorably with 18 years and 6 months of service. That will be fine, provided they have the DD 214 that actually qualifies them as a veteran. I'll take some last minute questions here if there are any. If not, thank you for attending.
We have a few questions to close us out. So the first one goes back to the DD 214. Why aren't veterans DD 214 forms required in Prosper as part of the documents required? Sorry, I have drilling outside my window. As part of the documents required to retire someone out to ensure that their veteran status is correct. I don't know if that's a question for you or maybe our developers.
Well, so I know that we request that if they're going out under ordinary disability, I believe that a document that proves their veteran status is required. I don't know for other calculations whether that is included. I don't know how Prosper handles a calculation sent into the actuarial unit. I can't answer that.
Can you change your verbiage on PERAC form 41H? If a member can purchase the days also, why does PERAC's form say years and months? There is a disconnect of the military time someone can purchase and the amount that the PERAC form will allow.
So I believe that this is an issue because of the fact that you can only purchase full months of creditable service. So you were technically purchasing, if you have 2 years, 4 months, and 14 days, you're only purchasing 2 years and 4 months at that time as a military buyback. The 14 days may come into play if there's some other buyback that's eligible, but at the moment, you can only purchase years and months. We can certainly look at the form and see if there's any. We're always willing to look at forms. I'm not off the top of my head familiar with exactly if that is an issue or not.
And do veterans offices have access to the NGB 22 form? Where does the member obtain that form?
I believe that the member can, I know that the member can get that by requesting it from the guard itself, but they may also get it when they get discharged. I believe that that's one of the forms that they get when they're discharged. They should have some sort of separation papers. They get a whole bunch of different forms, but they can also request it from the military service records and from possibly the National Guard Record Center for the state that they served their time. I don't know what veteran agents have access to. I don't know what sort of access they have to personnel records. I'm not familiar with veterans agents.
All right, thank you, Patrick. All right, oh, we have one more question. I was about to close this out. Someone came back. The days is an issue as PTG won't let the days roll, so the buyback only allows for months and days based upon the PERAC form. More of a comment than a question.
That seems like it's a PTG issue more so than, I don't know if there's some way that the boards can track those days for future if they ever get to an extra month or something. I don't know how that would work at the board level.
All right, I don't see any additional questions coming in. So we have come to the end of our presentation. Thank you so much, Patrick, for a very informative presentation. I hope you all learned a lot from this presentation. Again, as I mentioned before, any board members who have attended today's event will automatically receive their 3 credits. We will also be posting this presentation to our website at a later date. And at that point, anyone who views the recording can also obtain 3 credits by submitting a training affidavit in Prosper. Thank you all for attending today. Enjoy the rest of your day and enjoy the holiday weekend. Bye-bye.